Yes. Item number 1. This bench. This is not a regular bench.
Item 1 may be withdrawn here. Infectious contempt. Complaint.
It is submitted. It is submitted by the learned counsel appearing for. In view of the above, the contempt application is dropped. Item number 2.
Item 2, kindly Lordship see the order dated 12/9/25. Your Lordship's order. Thrice Your Lordship directed to file the affidavit, and I think this is the last 12/9/25 orders. And prior to that, 2 orders, successive orders were there.
I do not know what is the ultimate order to us. What was the direction pass?
Direction, my Lord. Your Lordship, kindly see page 11. Consequently, instead of passing the entire equipment, which will affect a large number of meritorious candidates, respondents, state and opposite party are directed to prepare the merit list in respect of the candidates who have applied and appeared in the recruitment examination pursuant to the first advertisement dated 17/4/15 without giving any relaxations, restricting the reservation.
So far as the relaxation part is concerned, that was quashed.
So far,
They should provide the relaxation to you.
No. They can recast the entire select list. The entire select list.
Where is the?
On the basis of select list prepared, appointment order be issued in favor of the selected candidates. That is very clear direction.
Yes, let me go through it.
Yes, yes.
I have read it.
No, sorry, sir.
Let me.
No, I again submitting. That's kindly see page 11 and 12.
Yes. So it was directed that to withdraw the advertisement and issue a fresh advertisement.
No.
That was paragraph 19. I am looking
Para,
at this
para,
document.
yes, para 18 and 19. Yes, Lordship, correct. Para 19 and 20, the last.
They have today present. Directly not.
What you have done? Who is representing the less contender?
Annexure 3, that is the letter.
The LS contender is
Both are not state and
Satyabrata Roy.
Satyabrata Roy, he has to change it because he is the additional secretary. He is not the secretary. He is not obviously representing.
Oh, whatever. These are the two. Who is representing them?
Only thing, Lordship.
Just wait, sir. This is a contempt application. You are aware of the law. Any third party to the contempt has no right of audience.
What I beg to submit, what I understand.
Let us see. No. Whether the notices have been given?
Annexure 3, that is there. Annexure 3, they have given.
Contempt application notice.
Contempt notice is there.
Has been given? Who is representing these two alleged contenders?
I am for
Who is
OPS.
representing?
I am for OPS.
You have nothing to say. Who is representing two? Now this gentleman is still there in the service.
Two, but two is not the concerned person. However, I have We have appeared for the OPS secretary.
You can't appear. Is a contempt. And contempt is not against the institution.
But I owe the due.
Contempt is against the individual for
But-
their individual act.
That is right. But I owe the responsibility to
No,
apprise the
then-
court
Then you secure his permission to represent.
that I will have.
You'll have to secure his permission to
But
represent.
what I beg to submit, he has to make the proper party.
No. This
Satyavrat
is
Rai,
a contempt, sir. There is no concept of
My
necessary
lord,
and a proper party.
My
Like
lord,
Order 1 Rule 10.2.
that is right.
No concept. Contempt is against an individual who has consciously and willfully violated the order of the court.
He has not violated the order.
Let him come
He
and
is not
say,
concerned. Your
let
lordship,
him come and
all right.
say
Well,
on
Lord-
affidavit that I am not a concerned person. I have been wrongly arraigned as a party.
yes,
I have no role to play. We will exonerate him from the contempt. No problem.
present incumbent he is not. He is not.
He has been served.
Because secretary is to be
No,
to reference
not
to.
in a designation. A person who was in the helm of affair at that point of time, he is responsible.
But perhaps I failed to communicate. I failed to communicate.
I failed to communicate to you that what is the scope of contempt.
My lord, OPSC was the party in the contempt
Oops.
case and represented by the secretary. He is not the secretary.
Sir, again I am saying that there is a vast distinction between a normal proceedings and a contempt proceeding.
Right, right.
In a normal proceeding, the authorities may be arraigned as a party who are considered to be a proper or a necessary party. But the contempt is only against a person who have violated the order passed in the court, by the court. We are concerned with the individual. Even a composite affidavit in a contempt is not the proper way. Each individual has to file a separate affidavit
That is right.
showing his conduct that I have not violated.
I am not the concerned party.
That is what I am saying.
Yes, my lord. I
I name somebody is a party, he should either you can represent him, no problem.
my lord, notice has not gone. Let notice go.
So notice, that's why I asked whether the notice has gone or not.
No.
Not gone?
No.
Go. Serve the notice, contempt, notice has to go. The service returnable after 3 weeks.
Item number 3.
Number 3,
Okay.
the
Notice has gone,
notice has not gone.
serve a notice, 2 weeks.
Item number 4.
Serve a notice to the state government.
No, sir, alias contemner.
Right.
State. You have to give it separate notice.
Yes.
Item 4.
Somebody was representing the alias contemner. Now he is no longer. Are you the alias contemner? All yes. All 4. Notice has gone.
Notice is not gone.
Huh?
Not gone.
None appears in support of the contempt application.
For orders item number 5.
delay is pointed out 3 months.
What
Retired
is this, sir?
and all things. Delay has been pointed out by the SR. So 3 months, 10 days
Delay.
delay.
So we have already condoned the delay, sir. We have already condoned the delay. You'll have to move the, I think we have condoned on 12th of September 2025.
Yes.
So,
Now you'll have to move the review application.
yes, ma'am.
What is the order?
My lord,
What is the order you sought to review?
yes, ma'am. My lord, for not the mistake, omission of due to omission of records, the prayer is paid
Just
in the,
show us the order, sir. Where
yes,
is the
ma'am.
order?
In the writ of appeal.
The writ appeal. It should be there in the review.
Review out of writ of appeal.
Will you not annex the copy of the order passed in a writ appeal in a review application?
Yes, my lord. The
Have you annexed? I just want
yes, my lord. So
review application. Sir, you have not, how the review is entered, has been accepted without the improved order? Why it is not pointed out? Yes. Last order means? No, I understand. We have simply restored the matter, but I am asking the review application how it is entertained or accepted by the department without the certified copy of the order sought to be reviewed. It may be there in a writ appeal, but this is a review application. They must annex the copy of the order. Oh, certified copy of the said order. Oh, you have filed subsequently. Okay. Got it. No. Oh, review application which was dismissed. Oh, we have restored. Now section 5.
next sir, 5.
Section 5.
Section 5.
Which one?
My lord.
Which is the application IA?
IA 352 by 23.
342.
Yes, 342.
How many days delay, sir?
3 months, 10 days.
3 months, 10 days.
So,
What is the ground, sir?
My lord, the appellant petitioner retired. So, in between the statutory period, due to leg fracture,
any documents?
Documents, my lord, because this is leg fracture, it is attached in the limitation of petition. So, his right legs are fractured, my lord. So, the certificate issued by the attending physician.
Yes, what do you say? He suffered a fracture, then he can't move.
Senior citizen, 68 years.
Date of the order.
Date of the orders.
The medical certificate right.
It is of the 6 5. We have noticed. Sir, how can this be a ground?
Well, the discharge
No,
certificate.
sir. Your first date of the injury is 26/5. The impugned order was passed on 19/4. You applied for certified copy on 25/4. It was given to you on 26/4. So from that, you had 1 month time to file a review application.
My lord,
And then
in addition
you
to
suffered a fracture on 26/5.
my lord,
That is nearly on a 30th day.
my lord, the originally I
So
was
what is your explanation that
My
for
lord,
this 29 days,
my lord,
why you did not? Why you
lord,
did not?
my lord, with it-
No explanation, sir.
my lord, my lord, with
Very
it-
casual way of drafting
no,
a
no, my lord.
section 5. Yes.
My lord, I was not the lawyer in the writ appeal. So the file after handed over to me, I found that
I always say one sentence. If you have inherited the asset, you must inherit the liability as well. Can you say that I am already blessed with the asset? I will not bear the liability. This change of brief scenario is difficult, sir. Difficult.
I'll pay certain cost because retired man not
Sir,
getting pension.
Sir, explanation. You have simply two paragraphs section 5 application. Very interesting. The second paragraph says that as per procedure prescribed for limitation, that is also not fully typed. The review was to be filed within a period of 30 days. But the present review could not be filed within the prescribed time due to leg fracture of the petitioner coped with other orthopedic problems. As he is a senior citizen, old aged man, suffers from other old age ailments, to sustain, I do not know what is this, to stay his grievance, I do not know.
Substantiation.
Oh, to substantiate his grievance for immunity on medical grounds, the copy of the medical certificate is annexed. And medical certificate says 26/5
But the other
leg fracture, whereas you obtained the certified copy on 26/4.
But the other certificates are also available with him. So the
There is
admission
nothing-
and discharge.
No,
Admission.
this is a sir, a person who suffered a leg injury, he will be immediately given a plaster on the same day and will be discharged. He's never admitted in the hospital.
No, he was under long treatment because right leg. So I'll first
So
my lord,
I have seen the doctor has advised him to take rest for 1 month, 9 days. So from 26/5, 1 month, 9 days. I'm talking to you that what is the explanation between 26/4 to 26/5.
my lord, I pray for the period the satisfactory answer to be given to condone the each day delay. So
No. I am unconscious. There are one judgment which says each day's delay. There is a subsequent judgment which says that it's not necessary. Then why not each hour, each minute explanation? That's the Supreme Court observation. I am conscious, but there must be a symmetry of the facts. Continuity must be there. Where is the continuity?
So as far as continuity is concerned, my lord, I will explain because for the first time,
You have explained already, sir.
my lord, other plausible evidence might be to make petitioner. So I have not
On presumption and assumption.
No, my
That is what it appears. Might be there. So
No,
that
my
is what I'm saying.
pension matter.
You are presuming at the bar. You do not have the instruction from your client. That's your presumption at the bar.
Well, a retired person not getting any pension, some little bit of omission, not the records are well available, but due to certain omission to present the records, he lost his case. So the documents required to be placed, it is already in the writ petition, page 109 to 1036. So at the time of argument, it was not properly placed. So it is attached, so it is annexed. So for this omission, university first statute I am meeting all the requirement of clause 260 of the inverse past statute,
Can
which
you-
qualifies
can
me.
you- Can you say this be the ground for review?
No, my documents are there. Documents in the writ petition, not I am placing for the first time either to substantiate my claim in the review or a writ appeal. In the writ petition, it was there. But in the writ appeal, in paragraph 11, the Honorable my Lord, the Chief Justice and my Lord pointed out that he could not file the rejoinder or any written submission to substantiate that the past period are to be counted towards pension. But the service documents governing the past periods are already in the writ petition, page 109 to 1036. So it little bit of bona fide violation, the omission, due to certain omission, I lost my case. So initially, my writ petition was allowed. So it is the second writ petition. Out of second writ petition, the writ appeal was filed. Paragraph 11 of the impugned judgment of the writ appeal, it is mentioned. He could not file the rejoinder to that effect to substantiate that he was rendering service from this period to this period under the constituent colleges of the different universities.
Was it an aided institution or unaided institution?
My lord,
The
some are aided, some are unaided.
I'm
260,
asking-
my lord, university first statute, I am relying.
I'm-
No, so when
That
original,
document was not there.
yes, my
Just tell me that the Sambalpur University took a stand that the college which you were there was an unaided institution.
well, page 1092,
That
well, at the 260,
Sir,
sir,
260 has been taken into consideration. It simply says that the past period of service shall be counted, provided he was in an institution that is recognized by the university or aided by the state government. The court, earlier court, my brother was a party to that judgment, says that the institution where you have served was unaided because that was the Sambalpur University. They came forward, filed an affidavit saying that it is not aided. So the court has proceeded, since it is an unaided institution, then you are not entitled to claim benefit under clause 260 of the first statute.
well, at the 260, A, B, C, D, F, 6 contingencies are there. The period of qualifying service rendered by an employee under any of the following institutions shall count for the purpose of gratuity and pension. 1. A. State government, any Indian university. C. Any college affiliated to any university of the state and aided by the state government. C. D. Board of Secondary Education, Council of Higher Secondary Education, any recognized institution of higher education or research aided by the state government, central government. So
Sir,
my
the question is two.
My
Either it must be a university affiliated to the university, be it a state university or the central university, no problem. Secondly, if he is there in the institution, then that institution must be an aided institution. Aided means the grant must be given by the state government or a central government. The positive finding is that the institution is neither aided by the state government nor comes within that purview. So once it is outside clause 260, then you are not entitled to any benefit.
Yes, my lord. So in clause 60, A, B, C. So only clause C is interpreted added. So in the earlier writ petition,
Now again I am asking,
my lord,
can you come
recognize. I was
can-
also
can you say that this finding is perverse, the finding is a patent error? Can you say
my lord, because a little bit
it is a different, you are trying to take a different route?
no, my lord, A, B.
Whether you were an advocate in record at that time?
No, no.
No. Now I am putting another question. Can you give him AIR 1997 Supreme Court, page 1005 or 1007? Give it. Bring out that judgment. That the Supreme Court deprecated the review application to be filed by taking a change from the lawyers, even change from the arguing lawyers in the main matter, and wanted to re-argue by in the review jurisdiction. Supreme Court deprecated it that this will not be tolerated. If you look at the language, message is very clear. Language is such. Very harsh language. These are 4 paragraph judgment or 5 paragraph judgment. 1005 or 1007. 1005. How can you?
My lord, because case is listed to the fraud, so a little bit
No, sir.
I beg
No,
excuse.
sir. You can't.
So
You can't do it.
my lord, I
Sorry.
one chance, my lord.
Have you got that book? Yes. Yeah. One double 05. Second one. Right. The first one. No. 1997. EIR. Only first paragraph. Consider the language. Look at it.
Sure.
What are the language which are used? Read. Have you read the language? Have you noticed?
Sure.
Come to the last paragraph. Turn the page. Last paragraph, paragraph 5. Turn the page, paragraph
Sure.
5. No, you have not turned the page. 5. Yes, 20,000. So 20,000 rupees cost was imposed in 1997. Now we are in 2025. So nearly 28 years. So that 20,000 will now be added how much?
My lord, I oblige
Bound by
for
the Supreme Court judge. It deprecates the change of lawyer and then filing the review application and then rehearing. Everything has been deprecated by the Supreme Court, says not permissible. And 20,000 rupees cost was imposed on what ground? Read.
my lord.
Paragraph 5.
Paragraph 5.
On what ground? Read loudly.
No objection. The failure to obtain
No, paragraph, last paragraph. 20,000 imposed.
the application is dismissed with exemplary cost of 20,000 as it is an abuse of the process of court as in derogation of healthy practice. The amounts should be paid to the Supreme Court Legal Service
Correct.
Commission.
So, is in derogation of a healthy practice. So, 20,000 in 97. What should be the amount now in 2025? Must be at least 10 times. We are bound by the Supreme Court. What we can do? Article 141. So we have to follow.
My lord, I cannot venture to argue some more by before lordship after noticing the judgment, but as a court of justice,
No,
my lord,
we are bound by the judgment of the Supreme Court, sir. Can
Lord,
we take as a
my
court
lord,
of justice
he is not
or
getting.
equity can be done divorce the law? No. Equity must be in consonance with law or in tune with law. We can't ignore the law and then say the equity. This is a law declared by the Supreme Court under Article 141, binding. We can't defy.
My lord, he is not getting any pension, nor also gratuity.
I
So
appreciate it.
I
but
have not been with my lord, my lord, the absolute truth I am submitting. I have not been paid by so
that
because
is
it
to avoid that paragraph 6. I can understand. But what about? No.
My lord, may I pray? So the university, after a little bit some development has taken place in interpretation of 260 of the statute. So they are interpreting now the B, a service rendered under any Indian university. So on my representation, so they have taken certain steps by my lord codifying the documents. I was rendering the service before the other institutions which were not added but recognized and I was paid the amount by the university. So due to the pendence of this review petition, so they are not feeling well to process the file. So I
let
pray,
the review be dismissed. Now they will feel well.
my lord, I want to withdraw the review petition, because a senior citizen not getting a pension gratuity, if they will, see, they
There is
are
another judgment of the Supreme Court against you. That after a full-fledged argument, when sensing that the bench is against, a prayer for withdrawal of the case was made. Supreme Court deprecated it. No, dismiss.
because now I am at the age of 70. So I have rendered 30 years of service for the organization, rendering valuable service. So if they are
Consider it.
yes, ma'am.
He is withdrawing, we are not looking. Right?
Mild.
Item number 6.
Item 6 already complied. Complied.
The same order. Which I have dictated earlier.
Item number 7.
Yes, what is this? What is this, sir?
So rejoinder, I'm appearing today on behalf of the bank, my lord. Lord, if you permit a week's time, I can file the rejoinder, my lord. But here they have not complied with the direction of the Honorable Court. That is one of the factors I wanted to bring your lordship's notice. But more than 15 crores was the due. It was put to auction, different items of property. Sale certificate has been issued, and sale certificate is required
Yes,
to be.
yes. It was given on the last occasion.
No, right, I was given.
You were not there.
No, I am okay.
No, I was not
Why-
there. Last
why
time,
it was not, because they have disclosed that what impedes the due compliance.
exactly. I have seen that, my lord.
So,
But they have not passed the order. They have said we are constrained that we cannot pass any order, which is not permissible under law. Pending of a suit, intercept between the parties, we are not concerned about the civil suit. Civil suit has been foisted by one of the sisters claiming partition of the property, which is the subject matter of dispute here. But here it has already been put to sale. They knew that it has been put to sale, mortgaged and put to sale. Sale certificate only formally to be registered on section 89(4) of the Registration Act. It is only to be registered. Everything is over. Now sub-register says there is an injunction, but no injunction against the sub-register. He is not a party. Sub-register can be a party to a civil dispute where he is not a party.
then why not the CWAT principles will apply?
But here the question is, your lordship dealt with
When
the
a
matter.
non-party to a suit, if he is aware of an injunction having been passed, then he can also be brought within the purview of the contempt.
But here there is no question of contempt. Status quo order has been passed.
Whatever the CWAT principles originated from that a claim was made that I am now not a party to the proceeding. Maybe an injunction is passed. I am not bound by that injunction, so I am not going to follow it.
So
Not
here,
going to follow it. Then the question
So
is
your
whether
lordship-
you can be held liable for a contempt of court's order.
yes, that's
So
permissible under law.
The CWAT's case
But
that
here
was
the-
there,
but here-
that says that yes, once you are aware that the injunction is there, then you cannot, even if you are not a party to the.
But here actually it has been delayed, allowing the party to get the interim order. Question here is not that. The question here is there is an order of status quo. Are we clear, my lord? Status quo not to change the nature and character of the property. Status quo doesn't prohibit entry in the register for the purpose of regularizing the sale.
It is not changing the nature.
Nature and character of the property.
Is not changing. I'm not saying character. Character may be if it is a
Yeah.
homestead land, it cannot be converted into
Right,
agricultural
right.
or vice versa.
Correct.
I understand. That's the nature, but character. I say character. That's the nature.
So nature, it has already been sold. But kindly appreciate, it has been sold, sale certificate issued much prior to that. Sale certificate has been issued, only an entry in the register to be made. 89.4.
Prior to injunction,
Yes, it was done prior to injunction.
sale.
Sale is prior to injunction. It's not changing the nature and character as such. It's simply entry. And they,
Entry may not be a
nature of violation. Yes.
factor, but it has some presumptive value.
But here, let's me kindly appreciate. They should have rejected my application. No, we cannot entertain. But say we cannot pass any order. Honorable Court said you dispose of. They have not passed any order.
Why don't you go there and say sought for variation?
We have approached.
Variation of the order.
So they have what they have done. They have filed a CMP. The other side, CMP, there is a stay of further proceeding the suit. But that is the game they are playing. That it should not be materialized.
And the suit has been stayed.
But here the question is: a person has
CMP against which order?
High Court.
Implicit.
Implicit of party. We wanted to bring it to notice the court. Yes.
Against your application,
It has,
the one rule 10.2.
That has been allowed.
That was allowed. They have.
They have challenged it.
Already a party to the proceeding.
Sir, now they have
CMP.
challenged, stayed it.
You are party to a CMP.
Just recently, we have been implemented as a party. After we came to know about this interim order that has been passed.
Without implementing a party, CMP defined.
Yes.
Challenging that.
No, that's right.
What is that number?
The CMP number is
It doesn't give for reserve. Judgment reserve.
653 of 2023.
And the matter is kept for judgment.
Where?
Before my lord Justice S. Mishra. It's interesting that plaintiff has not been challenged that murder Miller, but the brother who has not been noticed even in the civil suit.
And he is not
has
the
challenged
plaintiff.
order.
A defendant challenge.
The bar under the civil law. If he is a party to the proceedings, even if he is not noticed, he has a right to challenge the order.
A defendant files a
So what? If a rival claims amongst the defendants are there, and in a partition suit, you know the concept of defendant and plaintiff is completely gone. Everybody is a plaintiff, everybody is a
in a suit
defendant
for
in a
partition.
partition suit.
Interesting, he has
So
filed
there
also
is a
surface.
difficulty.
Yes. And interesting, he has also filed surface application before this DFT, under section 17. That brother who has filed this CMP minutes.
So he wanted to get away with the order that must have been filed by the DRT in a SARFASI proceedings.
But here actually only
Must be in a SARFASI.
Yes.
It is under the SARFASI. SARFASI Act, section 17, you have to approve. Section 13
So
to
they are
notice
to challenge. They are to
13
challenge.
for
Right.
steps have been taken. Section 14 order is already taken from the magistrate.
Yes.
Right.
And then 13 for the position has been taken because of Rule 8 of the
Correct.
security
Rule 8,
enforcement
Rule 9 cell has been affected.
affected. Now what to do
So only
by the recovery officer?
so this the status quo order also doesn't affect entry.
Sir, you are a civil lawyer, you know better.
But your lordship remembers
You know better.
Justice Anand Behra sir passed an order regarding registration. I challenged in writ appeal. Your lordship said, sir, registration doesn't make any difference even if pendency of the suit is concerned.
No, there was no injunction, sir.
No, there was interim order was there.
There was it was in relation to something else. Not to create any or not to disturb the position. If the injunction is there, mere registration does not tantamount to giving of the position.
So here also, sir, kindly say status quo. Kindly
That's a
appreciate.
more ambiguous order, sir. The status quo order is more ambiguous. than a straightforward order.
The status quo must relate to the prayer made. Law says status quo must relate to the prayer made in the application.
Release claim.
Right.
And it has to be understood from the context or the facts which has been pleaded there in the injunction. Should not apply it. That's why I always say status quo is
Here actually they have.
capable of being misused.
Sir, if your lordship
to
looks
the
at
greatest of ends.
if your lordship looks at the tenure of the order that has been passed, it is neither here nor there. If your lordship looks at the order, he has not disposed of the application. What the Honorable High Court said, you dispose of the application. I can say, I can understand, sir, we have been restrained.
But no, I don't think so.
They have not passed any order. Sir, no order has been passed. No, Annexure A by 2. Kindly have a look at Annexure A by 2.
Now, kindly come to page 31. What is the direction? Consider and to dispose of the representation.
Yes.
Representation was submitted for registration of that document. Now, as you kindly come to.
So you have rejected on the ground that the matter is pending.
Yes, sir.
No, not rejected. Sir, not rejected. Let me show that he has rejected.
That not happily worded. Put on to an
A by 2.
Yeah.
Page 5 of the counter, if your lordship looks at.
Counter?
Yes, consider not to entertain.
Where is the counter?
Page 5 of the counter affidavit A by 2.
You have not disposed of.
They have not disposed of.
What you have said that this is for your favor, this is for favor of your kind information and necessary action.
Sir, no order has been
You
passed.
take a necessary action to remove that order of injunction or clarified it, and then you will consider. That means you have kept it pending. They have not finally disposed of.
That information are given to that may count email. And they have suppressed that is content application.
Suppressed.
They have not.
We have brought to notice of the Honorable Court's order, and we say that this is the order that has been passed.
Facts are not written in the record.
Is in respect of a suit schedule land.
Yes,
The
but
order of status quo is in respect of a
suit schedule land.
So the land, anything which really creates any kind of an interest or impedes or interferes with the interest, it will be covered under the status quo.
So I bow down to your lordship, what your lordship observes.
It cannot be, it cannot.
So they should pass an order. Let them pass an order rejecting that no, your application cannot be entertained because of this.
Which one?
They have not passed any order. If they pass an order,
we cannot hold them liable for contempt. We are in a contempt jurisdiction, sir.
No.
We have to see that whether there was any willful or conscious deliberate or violation of an order of the court.
Correct. But
if they say that this is because the law interferes and intervenes in the meantime, and there is some kind of the obstacle which is created, and this has been highlighted to them, we can't hold them guilty of contempt.
So
we
what
can't hold them guilty of contempt.
So what I beg to submit, Malad, what I beg to submit, I can understand willful negligence is one part, Malad, that is
Sir,
correct.
even a violation of the order per se
Right.
does not tantamount to a contemptuous act. It has to be willful, deliberate, and conscious. They have not done it.
But I'll just
Because you look at the definition of a civil contempt.
But I bow down. I ask a question to myself, Malad. I'll ask a question myself. But in these circumstances, a person has deposited 15 crores rupees and taken the property on sale. He has given sale certificate. He cannot develop the property. He cannot do anything in the property for which actually the bank will be held liable. If no registration will be done, entry will not be done, he cannot get the absolute right to the property, and he cannot get absolute right to the property was
Why not?
purchased.
Sale certificate itself creates a title.
So sales, but without the entry in the sub-register, he cannot further transfer it and he cannot do anything. But that predicament is there if intestate they file a suit for partition, and which is prohibited by the Supreme Court. Supreme Court says if the matter is pending for DRT, you cannot maintain a suit. Now they have
because of the exclusion or the ouster clause.
ouster clause in the statute itself.
It's there.
But now the question is, but bank is to be liable to refund the amount with interest the person who has purchased if he says that no, you have to refund it. But this is a public money.
If you have sold it on a as is where is basis, then it's a different thing.
But it's an auction sale.
Auction sale, when a proclamation or when the advertisement was
But here the
made, if it is
public
as
money.
is where is basis, then
So-
what?
But this is a way actually they want to obstruct and create an obstacle
You
for the
go
purpose
there
of
and get it done. You go there and get it removed. But
you,
contemptuous, we are not saying that you do not have any right. We are not at all saying anything which will really impedes or interferes with your rights. But we are concerned with the contemptuous act on their part.
so your
If we
lordship,
do not find that this can be termed as a contemptuous act, then why we will keep the contempt application pending?
but a simple observation will be sufficient for me to challenge it,
Is it
saying
contempt?
no, not contempt, no contempt. They should dispose of the application as per direction of the
We
court.
can't. We'll say that because of the intervening order.
No, they say no
the
order.
intervening order, if they thought not to, they cannot proceed. We can't hold them liable for contempt. We can't hold them liable for contempt unless there is a variation, modification, or a vacation of the interim order. Can't, as you know, the language of Order 39, Rule 4.
But I can challenge this order in an independent writ application.
Through independent
Writ application. This order,
this order,
yes, Lord.
you can.
I can challenge it in an independent writ application.
And what would be the fate? I do not know.
Your lordship knows, Lord, this cannot stand. In fact,
Why not? I fail to understand.
so
Why not?
reason being, inter se suit, if any order is passed, number one, that is not binding who are not parties. Merely because it is brought in.
Just can you give me a contempt of courts?
Your lordship wants to act.
You will not get it. Annotated book of a contempt of courts act. Do you have?
Just a second.
A or SEWALD.
Seward versus Sikorsky.
Correct. That is the Seward principles. Can you show me that judgment? SEA, SKA not. SEA, C means Samudra. See what's principle? Apostrophe S. Not clearly. No. In contempt. Sorry. Yes.
Okay.
Yes. This is a Seward versus Patterson. This is reported in 1897, 1 Chancery Division, 545. is a legal rule that allows the court to punish for a contempt of a court a person who is not a party to an injunction, if that person knowingly aids and abates a party in breaching the injunction.
So that I don't dispute about that.
So
if a
I
person
think
is-
this has been accepted as a legal principles in our jurisprudence as well. And the courts have used this as a difficult, sir. It's very difficult.
Can I just request one thing, Malad? I'll say,
खाता है जी ना ना ठीक है
Pillai. Ah.
Description बनाई थी उसमें कहीं
see what principles here in our legal jurisprudence. This is a, you can read that judgment.
But I have,
Piece of the Delhi High Court is there. You can term this as the Supreme Court judgment because the author
right.
subsequently went there. So this is a Krishna Gupta versus Sri Narendra Nath and another.
I've taken note.
And I can give you the certain other cases of the Privy Council as well, uh, which has been considered here. That is the AIR 1938 Privy Council, page 295. Again reiterated in AIR 1991 Madras 323. In all the judgments, this Seward versus Patterson, which is again followed in Atkinson versus Atkinson in 1952, Volume 2, All England Report 567. Even a division bench of the Andhra Pradesh has been very categorical on this. Very, very apt observations. So, sir, if he knows of the injunction, how can we direct him to violate the order?
I'm just praying one thing, my lord.
We can't direct
No,
him to violate the order.
So I'm not insisting for contempt right now, my lord.
We are saying that the contempt does not lie per se on the face of it. Now you take your decision. We are simply concerned with the contempt. We are not concerned with him.
There's no contempt lies in view of the order passed. But Your Lordship, one line can be added, open for the petitioner to approach other authorities.
That is always there. If a right is there in the statute, why court will recognize that right?
The reason being actually no order has been passed.
No. The contempt application is
With respect, you should use the word deferred. That's
Hey, open comment.
Well, item 8.
That's a deference, actually.
that's right.
Yes.
May I please, your lord.
Paul, which one?
Item 8.
8. Yes.
Lordship says that you have filed a show cause reply, my lord. The against the item 8, they preferred SLP, but there is no stay order in item 8, your lordship.
Now, have you seen the recent judgment?
Yes, your lordship.
That
No,
once the matter is in session of the Supreme Court, then there should be. So once it is there, we defer. The order is before the Supreme Court and the notices have been issued.
In this case, not, my lord. I have given the chart, my lord. I would this is today list, my.
Pending as
Any notices have been issued.
No.
notices have not been issued.
It is informed to the court that
I have to take
assailing the order for which
My lord, I stay 9 stays granted.
Stay.
My lord, I have given note to your lordship list in which case
Oh,
the serial number 9 is stay, 13 is pending.
so give me the order.
Stay.
Says the
9 is stay.
the order on which the complaint is made, for which the complaint is made, is challenged before the let us dispose of this. 13 also pending, the first order.
Yes.
In the second week of December. Item number 14 also stays granted.
Take
that. Give that order. SMT. This is item number 9.
Okay.
Yes, remember. Correct. Now he's giving item number 14. Give that order.
I'm just giving.
Same order, stay has been got. Okay. Like 9. Only the SLP number will be different. Or date may be different. Give me that order in 14.
I'm just download.
Just give it. Give us. It's now
Item number 10.
Picking order is fast and then claim is not entered because they wanted they should be compensated in terms of cash flow and a high cash cost first and before that then committee they agreed and 2 crore 96 plus has already been paid.
Your Lordship, 148 families are displaced in 1977-78, my Lord. Just, my Lord, thereafter, after 35 years, there are different committees formed. They find out the rehabilitation scheme is they will give
alternative land.
50 decimal dwelling house, dwelling house land, that is
Homestead land.
homestead land, and 3 acres irrigated land or 6 acres unirrigated land. That is the
They are
scheme.
giving you money.
Your Lordship, my They, in the 2012, my lord, as they could not provide, so they have given 2 lakhs as SDLCR to support their sustenance.
But now they say is 2 crores or something.
No, that is for each family. For each family, there is 148 families. Displaced family, my lord. Each family 2 lakhs as support for their as SDLCR, my lord.
What is the order?
My lord. Here is 69 people, my lord, out of
What is the order?
Order was to dispose the representation of the applicant.
So they have disposed of the representation.
They have
What
disposed of the
remains?
applicant in
What remains?
not all
Maybe, sir, that gives you a fresh cause of action. You go and challenge it. But it can't be done. If they have already disposed of the representation, one way or another, correctly, wrongly, so go and challenge it. Whatever, they challenge it. We can't do the contest. Where is the compliance order?
Complaint would be.
I don't.
Like yes, sir.
21 and 20.
A by 3, A by 3.
It's already complied with.
Yes, sir.
No.
Our affidavit by A by 3 and page
Yes,
8.
we'll dispose of. And liberty to challenge before the appropriate court. Yes, call the next.
Item 11.
11 after same.
Same. Same order.
Fine. Item 12.
12 has also been complied, my lord. There was a direction for representation to be disposed of. That has been done. My lords will see our affidavit is at flag B and page 7 of the affidavit. That is the speaking order. And the order passed by
Same order will be.
my lords.
The petitioner is not required to be heard because he is simply an informant. It's a matter between a court and the contempt.
My lords.
So we are disposing
My
of it,
lords.
even if he is not here.
My lords. Over.
Others, over. Give those files to. Yes, okay.
Yes, admission item number 1.
Come to mention on Monday.
Yes, fine.
Come on Monday. Come on Monday. Come.
Your lordship, may I please? Your lordship is a very urgent matter. For that reason, I'm just making a simple.
Come on Monday.
Item 1.
May I please your lordship? Item number 1. Well, this is a PIL requisition with a limited prayer to consider the representation pending before the OP number 2, Annex 1, your lordship, following the Orissa Government Land Settlement Rule 1983, Rule number 4, Surplus 2, your lordship.
What? What?
Your lordship, the villagers of Gopinathpur were from district Baleswar were using one Gochara land of across 0.5 decimal for the grazing of cattle and communal function, your lordship. But exercising the power under Odisha Government Land Settlement Act 1962, Section 3A, power to de-reserve the land. The authorities have de-reserved the land and allotted that land to some private school, your lordship. But according to the rules of under 1983,
Ms. Punda,
yes, your lordship.
is it your argument that under Government Land Settlement Act there is no provision for settlement of Gochar land?
Yes, your lordship, there is a provision for de-reserve of the Gochar land, but with some certain terms and conditions, which is under the Odisha Government Land Settlement Rule 1983.
Madam, I have not made out a case in your petition. It is such a casual way of drafting a public interest litigation. We cannot. You have not made out any case. You have not said that what the provision of law is. Mere allotment of land to a school, that does not mean that it will come under the PIL. Unless you lay a foundation.
Yes,
Absolutely cryptic. No, I am now becoming a very, very strict in this regard.
This is a simple consideration of the representation pending.
You have chosen a bad judge. I do not propagate further litigations to come by disposing of the writ petition to consider the representative. Sorry.
Yes, sir, but the problem
As a PIL, no, you'll have to show.
There is no appellate period is over, your lordship. Here religion is done.
We can't.
The appellate period is over, your lordship, who is ties our hand to proceed with the matter.
It's not a case of a no. Okay, the PIL will come. Unless you make out a case that there is a prohibition in the act that you cannot change. Sorry, we can't.
Your lordship, the appeal period is over. That's why
Sorry.
I have no other choice to.
Sorry.
Kindly consideration of the representation, whatever may the result be.
Madam, I'm again saying you must show your right. You must show that there is a violation of law. Unless you show us, we will not simply direct the representation to be considered. No.
Your lordship, no doubt my petition does not consist of the rules and regulations or law, but
Sorry,
I
you
have.
have not made out any case. Sorry.
This way they will be prevented from any Gochar land.
Sorry. We have noticed it.
Yeah, please, your lordship. This is a PIL, my lord. This petitioner is a retired school teacher from Baleshwar Jilla School. My grievance is that the Tahsildar Baleshwar, Opposition 10, by violating the order dated 12/4/2002, passed by the collector of Baleshwar under Annex 5 series, not recorded to the school field, that is old stadium, in the name
Is
of
it the PIL?
my lord. Kindly
It
see.
is the PIL. Again, I am asking.
Yes, my for the interest of the
it's a personal grievance of a person whose name could not be recorded.
One PIL also pending, my lord.
Maybe
Kindly see the same similar.
I do not know. Satisfy me on this.
Yes, my lord.
Mere irregularity or the illegality does not mean that it has to be perpetuated for all time to come.
For the interest of the children's, my lord.
To us, that what is the public interest?
For the interest of the children's, my lord, kindly see, my lord, for the interest of
how the interest of the children can be saved by recording the name in the record of right.
No, my lord, kindly see the order. Kindly see the order of
imparting the education.
Order Baleswar, Collector Baleswar. Kindly see the Annex 5, my lord.
What it relates to what?
To record the same field in the name of Baleswar Jilla School on the exchange, my lord.
So does it impede upon any education of the children? They are to be imparted.
My lord, now they are constructing.
Only thing is the name.
My lord. What? And now they are constructing a Kalyan Mandap over the said field, my lord.
What?
Said school field, my lord. Constructing a Kalyan Mandap, my lord.
Where is your allegation?
Yes, my lord. Kindly see.
Where is your allegation?
And my page 1, my lord.
No, in the pleading.
Paragraph 18.
Pleading, my
18E.
My lord.
Paragraph 18E, page 15.
Yes, my lord. Yes, for a committee was formed under the chairman of the collector from district magistrate and all the officers, including executive officer, Valsar municipality, and members were present in the said meeting held on 12/4/2002. It was approved that the permit field in the Bagundan Muja shall be used exclusively by the district athletic association.
What does you say? How can you?
Well, the allegation is made that it is being used otherwise by the Baleswar municipality. Notice is to be issued to the Baleswar municipality.
My sir is there. I have also
copy just served on me. I am for Baleswar municipality, opposite part number 9.
2 weeks time to respond. Counted by respond by way of an affidavit. Rejoinder 1 week. Matter to appear after 3 weeks.
Another submission.
My lord, my lord, now they are continuing school field. Sorry, Kalyan Mandap till the status.
Mr. Karunapratha has appeared on behalf of opposite part number 9. Let him take instruction, let him file affidavit. Let us see what happens.
So far, the second prayer is concerned relating to mutation of that ROR, Millard. Tahsildar has
not concerned with
instructed
the
all its steps are
concerned how the property of the school can be utilized for this auditorium. I mean the mandapa.
Yes,
which will be used or utilized for the commercial purpose. How can you do
it? Along this rate question, my lord.
Not. File.
Item number 3.
File your response.
Obliged.
Wait, please, my lords. Well, I appear for petitioner in this case, my lords.
Yes.
My lords. This is again a public interest litigation, my lords. We have filed, my lords. The subject matter involves, my lords, the enforcement of the obligation of the state under the
enforcement of
the duty with the state insofar as continuous production of mineral resources is concerned, my lords. My lords, may I?
State is doing that.
Yes, my lords. May I bring you to, my lords, my representation, which I made to the state authorities before filing this PIL, my lords. My lords, just bear with me for a minute, my lords.
What is this representation? In the representation, we are not going to see the representation. Again, the representation concept.
No, my lords. I made a detailed representation as to what is the status in the state of Odisha today, and how this impacts.
How you have pleaded in your
yes, my lords. I have
petition. Tell me.
Yes, my lords. Please have, my lords, page para 15, page 9 of the petition. Para 15, page 9 of the petition, my lords. My lords, I've given an example, my lords. Today, my lords, there are 63 RNO leases, my lords, in the state of Odisha, my lords. With an
paragraph 15.
Para 15, my lords.
13.
15.
Yes.
Page, para 15, page
Yes.
9, my lords.
Yeah.
My lords, have it?
Yes.
My lords, as a matter of fact, my lords, just a background as to why para 15. In the state of Odisha, my lords, there are around 63 valid leases with respect to iron ore, my lords. and the total EC capacity, the environmental capacity is around 246 MTPA, my lords. Now, my lords, if you look at, my lords, para 15, one of the illustrations I brought, if you just look at the Balda iron ore block, in terms of the mining plan and EC, having an EC capacity of 15 MTPA, my lords, it has, and its previous production of 10 MTPA, I've recorded in the last 4 to 5 years what has been the production. If you see, my lords, 2021, it was 1.39 MTPA, which was 9% of the EC. In 21-22, my lords, it was 0.58. In 22-23, it was 0.28. And it was in 23-24, it was 1. The last, from 2021 to 23-24, the production has only been 3.65, which was around 6%. What my interim prayer is, my lords, because I don't have this data, this is what I could gather. So in the interim, my lords, I've made an interim application saying they have all the data. Whatever in the last 3 years, my lords, the mines which have not been able to optimally produce with respect to their EC capacity, if that data can be furnished, my lords.
Now, what is the law on the subject? This the production values or the production capacity.
Yes, my lords, may I hand over a note, my lords? A brief note which captures my.
What is the law?
Yes, my lords.
What is the law on the subject?
May. My lord, please kindly come to my lord 12 EE. My lord, please the rule page number 13. My lord need not bother. My lord, page number 13 I have extracted, my lord. At para 23, my lord. MCR rules 2016, my lord, at 12 EE. May I read, my lord? If the lessee fails to carry out or perform any of its obligations hereunder or under the lease date within the time specified in that behalf, the state government may cause the same to be carried out or performed, and the lessee shall pay the state government on demand all expenses incurred in this regard by the state government, and the decision of the state government as to such expenses shall be final. This entire petition, my lord, is agnostic to whether capacity is there, minimum production is there. We are not concerned about that. It is a macroscopic petition, my lord. What happens? No, may. That the state of Odisha has more than 16% of the almost 30% of the entire iron ore reserve of the country. However, my lord, the production is approximately 60% of the EC limit. The mineral policy of the country requires Odisha to produce to the optimum level so that the economy can accelerate to the level required under the policies of both the government of India as well as the state government. Merely imposing penalty, show causing them will not suffice. My lord, I have demonstrated, my colleague has just shown 2 paragraphs and 2 tables, whereby for the last 3 years, my lord, please see at what level these mines have been working. And there is, apart from revenue leakage of 1,000 crore, let's say somehow per year, somehow the state government may at some point of time get back to them and impose the penalty and recover. But my lord, what about the employment? And it is like water is slowly drying up at the upstream level, my lord, at the downstream level, at the direct and indirect employment level, my lord. It is severely affecting to the economy and to the persons, the last person to be benefited by the operation of mining at the maximum level, at the optimum level. That's my petition. Lord, please, may I hand over this 1 pager? Lord, I prepared a 1 pager. Lord, I have just handed over this 1 pager in short. It's a summary of the whole petition. Lord, please see. Please ignore the final prayer and interim prayer. I'll come back to it. The independent subject matter, the very first clause I have written, nothing to do with penalty, nothing to do with capacity. What I'm concerned here, is the inaction of the state with regard to the power which is already vested in the state. The present petition concerns the state's constitutional and statutory duty to ensure optimum utilization of mineral resources and protection of livelihood and public revenue. Under Rule 12(1) EE of the MCR, state government has the right to cause performance of obligation. Let's say, assuming for a moment, the lessee concerned has failed for whatever reason, be it a force majeure reason, whatever it is. In that case, the state government has the power to step up, either do it by itself through OMC or through national national mineral NMDC, National Mineral Corporation. There are agencies and instrumentalities of the both the state government as well as the central government having enormous amount of experience to operate the mine, and the rules also makes provision that in that case all the expenses whatever is incurred by the state and the central agencies will be attributable to the lessee. After deducting that, the state can earn revenue, the employment can be generated, and the optimum utilization of mineral resources can be achieved. So therefore,
once the lease is already created in favor of the lessee, in accordance with the provision of the Act,
sir,
can there be a re-entry by the government during the currency of the settlement?
Yes, that is 12(1) EE. My lord, may please, my lord, may kindly have the MCR.
How the government can?
Yes, my lord, may kindly see 12 MCR. My lord, MCR terms and conditions of a mining lease. If your lordships will have the MCR, and if we are at the same published
Yes,
rules,
which one?
466 page. If we are using the same variant.
It is the minor concession rules of,
or the other than atomic and hydrocarbons energy minerals concession rules.
Yes.
My lord, may kindly come to Rule 12, my lord.
Yes.
12(1) EB, no?
Yes.
Yes. Terms and conditions of mining lease. Every mining lease shall be subject to the following conditions.
Yes.
Madam, please turn over a few pages and come to the amended provision of EE.
Yes.
If the lessee fails to carry out or perform any of its obligations hereunder or under the lease deed within the time specified in that behalf, the state government may cause the same to be carried out or performed, and the lessee shall pay the state government on demand all expenses incurred in this regard by the state government, and the decision of the state government as to such expenses shall be final.
So that is a clause which says that if there is any violation of the terms and conditions embodied in the lease deed by the lessee, then in order,
the obligations, my lord.
in order to remedy that particular violation, if the state government has taken any steps or performed such certain duties which incurs the expenditures by the state, then that particular amount that can be recovered by the state from the lessee.
My lord.
That is what is the
Failure to perform obligations, my lord.
It's true.
Which is operating at a minimum level, my lord, at operating at the full throttle.
Now one has to understand that if the obligation is foisted upon them to make a minimum or an optimal production
utilization, my lord.
Utilization
Yes.
of the productions, if they have not done it,
yes,
then there is a clause for a re-entry of the government that it can re-enter into the mining premises and can take over. There's under the lease, under the Transfer of Property
yes,
Act,
yes,
the clause of re-entry has to be there.
yes, yes. It is by virtue of the parliament, but it is by married. The state government may cause the same to be carried out or performed, and the lessee shall pay the state government. So whenever there is a failure on the part of the lessee to perform its obligations, as in this case, obligation to perform, to operate to the optimum level, the state can step in either by itself or through any of its agencies or a MDO, whatever it is, to cause the performance, which is exploiting the mines.
level, then why not the government should run?
Yes.
Let the government run
Yes.
the mining. The government is not supposed to lose its revenue. They can generate revenue.
Milord, in this respect, I will take instruction and I will get back to you.
That he has flagged very important.
Yes,
because
I have taken note of
to a
that.
private individual is better than the government should run.
Yes.
It leads to employment generation and
yes,
not to stagnate.
My lord.
The stagnation of generation of further employment, that is to be.
An important issue is raised.
Yes, yes, my lord. Yes, my lord. And let them come up with the data in the last 3 years who all failed. That's my interim prayer.
Let them come with the instruction.
My lord.
It's called the
Any date.
what matter is called.
Item 4.
Your Lord, may I please your Lordship, Your Lordship, by order dated 30th October 2025, Your Lordship was directed to take instruction. Your Lordship was directed to take instruction with respect to calculation of interest furnished to the petition of Annexure 9, Your Lordship. Your Lordship, in Annexure 9, there is a calculation where there is, Your Lordship, I also admit, there is admittedly calculation error was there. Your Lordship, there was demand of 2 crore 46 lakhs. After this calculation, after my learned senior's read petition, I have calculated, my officer has calculated and reduced to 1 crore 63 lakhs, Your Lordship. So I may be permitted to issue a revised notice for recovery of that interest, Your Lordship.
Exactly. First thing is that you should make an adjudication by putting that, then the recovery.
Your Lordship. Your Lordship. Your Lordship.
To modify the order.
You have to give him the opportunity to place his own material to show that this much amount.
Your Lordship, this is only intimation. This is only intimation, Your Lordship. What the intimation which has been issued at Annexure 9, which is required to be modified, Your Lordship, I may be permitted to modify that and issue an intimation.
Have you asked him to furnish his? You have directly said that.
It is only for recovery.
No, it is this we have not issued.
No. You have not given any opportunity to place his material to show that even this amount is also erroneous. He must have some figures to show.
These are admitted.
No. You cannot say it is admitted. Notwithstanding admitted, what is admitted? Is he admitted? Is he admitting it? Is he admitting it? He might have shown in returns.
Admission is error. Is error. That's an admitted because he is admitted. But rest
My case is 7,000 not impossible at all. So let him.
No, that point is required. That point, whether on the last occasion also I have argued that Your Lordship is required. It is required to be decided whether the levy is justified or not. The calculation, Your Lordship, I am very much open, Your Lordship.
A copy of calculation, you just order upon it. If you have anything, you can on Monday.
On Monday,
Your Lordship.
Call it on Tuesday.
Tuesday. Okay. List is put on Monday.
Your Lordship.
Tuesday.
Get full.